Good afternoon. Let's get started. I know that members have double and triple bookings as it relates to committee meetings, and this isn't usually our time, but in the interest of moving certain issues forward, we decided to go ahead and schedule today, since we really didn't want to rush a product yesterday on multiple fronts. I do anticipate, members, that we'll go ahead and have another full committee meeting on Monday afternoon. I understand we're going back. We're going in the morning on Monday. Is that right? Under that assumption, then we'll have our regular full committee meeting. I think we'll have some bills that'll be ripe for consideration. But let's kick it off with the substitute you have in your folder on House Bill 349, LC 295525S. There were three issues that were identified, discussed, acknowledged at the last meeting that we had on HB 349. I know that as a result of conversations between our friends in the prosecution community and the judicial community and with the AG's office, we have what I believe is a good product moving forward that more importantly I understand the administration is comfortable with for purposes of moving forward today. Having to do with the right to appeal issue. Then there was a conversation on the child hearsay evidentiary issue, and then on the Wilson fix. Well, we'll get to that in a minute. But Mr. McDade, my understanding is, and just by way of context, if you could just very briefly lay out for us the compromise that you were a part of with our friends in the judiciary on the appeal issue and on the evidentiary issue. If you could do that briefly for us, it would be really helpful. Thank you. If you could come to the witness stand.
Thank you, Mr. Chairman.
Thank you.
Mr. Chairman, since we last convened, I had the pleasure of working with Judge Kathy Goslin, and on her behalf, she represented the Council of Superior Court judges, and we reached an understanding for compromise language on the appellate section. The thrust of the bill proposes that the proponent of evidence that requires a judge to rule on pretrial, if they suffer an adverse ruling by the judge, the bill seeks to guarantee an appellate review of that decision. The judges were understandably concerned about if the proponent was given a direct appeal, that would deprive them of the ability to control their dockets in a timely fashion. So the compromise or consensus that we reached, or the agreement that we reached, would be that we would agree to an imposed limitation on when we would get that direct appeal. And the limitation is that we must file the pleading that asks for the admissibility of the evidence to be ruled upon. We must file that pleading at least 30 days prior to trial. And that will give the judge that's presiding over the case the opportunity to decide when they want to rule on it and make a decision within their control. And then if we suffer an adverse decision, and if we choose to take it up, we must notify the presiding judge or the court within 48 hours of that adverse decision. So we're giving the judges control over their dockets by agreeing to back up the time frame in which this is going to occur to at least 30 days pre-trial. And that was at the suggestion of Judge Goslin, and with our consensus, we've agreed to that proposal.
Questions for Mr. McDade on that aspect of the substitute, that portion of consensus on the proposed substitute? Seeing none, can you shift gears over to the evidentiary issue and the accommodation made there?
In the child hearsay section?
Right.
Under Section 11 of the bill, of the substitute bill, we were addressing and asking this committee and the General Assembly to address a decision that was called the Bunn decision, B-U-N-N, a Supreme Court of Georgia decision, that basically restored to the code or made viable, if the legislature sees fit to include it, language in the child hearsay statute that says subject to certain procedural safeguards, if a child who is the victim of a crime makes statements to a third party, those statements from that child victim can be introduced as an exception to the hearsay statute with a number of procedural safeguards. over the years, the General Assembly had amended that statute to say not only the child that was the actual victim, but a child who was in the presence of the conduct and saw it as well. For instance, two siblings in the same bedroom, when one is being molested, both siblings experience a traumatic experience, one being molested and one seeing it occur. Many years ago, the General Assembly said that those protections should also extend to the sibling who is not the victim, but who experienced it by seeing it. In a decision by the Supreme Court years ago, the Woodard decision, the Supreme Court back then struck down that additional language that said the non-victim child statements can be admitted. In the Bunn decision rendered this past summer by the Georgia Supreme Court, in an opinion authored by Justice Namias, the current Supreme Court said that the previous decision was wrong, and in a constitutional analysis invited the restoration of that language that had been struck down as unconstitutional. And what this bill does is restores the language that the Supreme Court has invited you to restore. Procedurally, what happened was during the evidence code rewrite last year, because that sentence had been previously declared unconstitutional, it was omitted in the evidence code reconfiguration. This bill simply puts it back in the way the Supreme Court says to do that. Now, the additional or the
language
change
that was struck in the bill as introduced.
In the original bill that was introduced, in addition to addressing the Bunn decision, the bill as proposed offered a number of other criteria that the court could look at and determine if those criteria standing alone would give the court standalone authority to also introduce a child hearsay statement. I think Representative Coomer asked a question possibly about one of the criteria, and some others. Representative Pack also asked whether or not those criteria had been vetted in light of the constitutional interpretations in the Crawford decision, the U.S. Supreme Court decision. And rather than risk a single line of the bill, we have made the decision, and we're asking this committee to allow us to make the decision to simply limit the bill that's moving forward to the original question that was answered in Bunn. So we have stripped out of the bill, or we are asking the committee to move forward stripping out the second part of that bill, just making it even shorter.
Any questions from the committee for Mr. McDade on the changes really having to do with the child molestation section? Seeing none, thank you, Mr. McDade. I know that there was an additional question that we had regarding the wording on the Wilson decision. We've had some conversations. I think we've got some consensus on it, and it really went to the use of the word knowingly. Of course, the Wilson decision went to the whole idea that on possession, the prosecutor would have to prove that the defendant knew the exact amount of the drugs that were in possession at the time, according to the construction of the statute, a poorly worded statute. So the wording that we have right now will go ahead and fix that problem. I know that we had some questions regarding the word knowingly as related to delivering and so forth, the law of unintended consequences. Under current law, I'm going to go ahead and ask counsel to chime in just as soon as I finish this sentence probably. As a practical matter, the prosecution has to prove intent with anything, so we have the UPS driver situation where has some drugs on board, and as a practical matter, they have to go ahead and prove intent that they intended to deliver these drugs, and that's current law right now. There's nothing in the bill as written as it relates to the Wilson case fix that undermines that current law, and certainly doesn't undermine a situation or set up more of a situation for, let's say, that UPS driver to have a bad situation occur of not of his or her own doing. Counsel, do you want to chime in on that? You're under no duty to do so, but if you wanted to. Oh, wow. Wish I could get that every day. Thank you. I appreciate it. Any questions on that? Okay. With that, given the fact that we had our public testimony last week and with the explanation on those changes or lack of thereof, Chair will go ahead and entertain a motion if there is one. Mr. Vice Chair.
Mr. Chair, I hereby move that House Bill 349 LC 295525S that it receive a due pass recommendation.
Vice Chair moves due pass HB 349 by substitute LC 295525S. Is there a second? Second by Mr. Hightower. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you. Thank you, Mr. McDade, and thank you to Judge. Is Judge Gosselin here? Oh, right in front of me. Sorry. Thank you for engaging in that conversation, and hopefully it's a productive result. The bill moves now. It'll go to rules. It'll go to the floor. And of course, it'll go to the Senate. I know that my recent sense is that there'll be some continuing conversation on those provisions. Obviously, with this bill coming from the administration, I think it'll be important to have good, clear communication and collaboration in order to keep the bill moving forward and realizing our common goals on it. So with that, is Representative Lindsay here? No, he's trapped in a meeting with Chairman Meadows that I just came from. So let me ask Chairman Weldon. Is Chairman Weldon right there?
Thank you, Mr. Chairman, ladies and gentlemen of the jury.
Well, there's probably some accuracy in that a little bit.
Well, you know, always they say start off with a little humor. It's usually intended, though. I bring before you House Bill number 146, LC 295396. This bill addresses the issue of video conferences for the purposes of issuing warrants. Arrest warrants, and that's what it does. It provides that a judge may issue an arrest warrant or a warrant in a video conference so long as he is within the state of Georgia. This addresses some issues that have cropped up this past year and clarifies the authorization of the courts.
This 146 came out of Mr. Ramsey's subcommittee. Mr. Chairman Ramsey, Mr. Chairman, do you want to go ahead and speak to the bill at all, or any, I wouldn't say report, but just any comments you may have?
It made a lot of sense to us, and we passed it out with very little discussion, Mr. Chairman.
Understood.
This applies to search warrants in addition to arrest.
Any questions of the author? Mr. Vice Chair.
What's the ground for requiring the judge be within the state?
Well,
I mean, what is the constitutional violation or statutory violation of that?
I'm not aware of a constitutional violation if the judge is authorized to do it. Right. This just requires that he doesn't have to be in
or she.
The Catoosa, the Catoosa County Magistrate Court can be working in a sister county doing a conflict hearing, and if he needs to, he can pull his computer up. They can do the hearing from Whitfield, Walker, or whatever other county he's in within the state, issue the warrant, and that takes care of that. But now, if they were out of state, they just want them to be within the state. They could be at St. Simon's getting CLE, or anywhere else in the state getting CLE. But I'm not. I asked that same question, and we just would like to make sure they are within the state.
Any further questions for the author?
I just ask for your favorable consideration.
I said we have one witness signed to speak on the bill. Pamela Perkins. Is it Karn or Korn? Oh, I'm sorry. Got the wrong bill. My apology. Jim Altman with the Magistrate Court Counsel. I'm sorry. Reading the actual numbers is a key component of success here.
Yes, my name is Jim Altman. I'm a magistrate in Fulton County. This has come out of the Council of Magistrate Court Judges. And in 25 words or less, when we're doing electronic warrants, the officers are at computer terminals. My example will be Fulton County because that's where I'm from. All the APD zone precincts have units, homicide, special victims, hit and run. The city of Roswell, Alpharetta, Johns Creek, Sandy Springs, they all have units. And we have a unit at the courthouse. Those of us who do outside of regular business hours have units that we have at home. And we do a video conference. The officer writes up the warrant application. We read it on our screens. We're looking at each other. We can talk to each other. and ask any questions. If everything is in order, we both sign on little signing pads, and the warrant is issued. The thing we're trying to do here, and the best way I can give you an example of this is, I do overnight warrant duty, 6 p.m. to 6 a.m. My family decides that we're going to have a family get-together that night. I can bundle up my laptop and take it over to my brother's house and do warrant duty from his house. As long as I've got an internet connection, I'm connected. He lives in Fulton County. I cannot take my laptop to my mother's house because she lives 90 feet into DeKalb County. That's what we're trying to address. We're going to have iPads soon where we can do this on an iPad. If I need to run to the grocery store in the middle of a warrant duty session, I can't go to the nearest grocery store. I live in Grant Park near the zoo. The nearest grocery store is Edgewood Shopping Center, 60 feet into DeKalb County. I'd have to go somewhere else to find a grocery store in Fulton. So that's what we're trying to do, is solve that problem. We appreciate your consideration. We hope you'll look favorably on the bill.
Any questions for Judge Altman? Mr. Pack.
Follow-up, Judge. Thank you so much for coming. I have a question about the physical limitation of the judge.
Yes, sir.
I see a problem in the small rural circuits where the judge might be in Alabama and the agents or law enforcement need a warrant signed, and that the judge would actually have to come back into the state in order for them to issue the warrant. So I'm trying to, if we're giving the fact that the judge's physical location, we're trying to expand that out, and taking that to the logical step is, what difference does it make if, in fact, the judge is authorized to issue such a warrant, and then you have the judge is able to determine the veracity of the witness swearing the warrant? Why are we limiting it to just Georgia? Why not just kind of, is there a constitutional issue with that? Or?
Well, I think it was concerned that there was a constitutional issue as to whether or not the state of Georgia, whether it be the Constitution, the legislature, would be able to authorize someone to exercise the judicial power of the state of Georgia other than within the state of Georgia. And I think we just didn't want to go that far, that there could be an issue. What it brings to mind is, for years I practiced family law. Every year I go to the Family Law Institute, which is in Florida. For years and years, Mr. Justice George Carley would attend it. We'd always have breakfast together and talk. One year he was on a death penalty watch on a case and had to stay in touch in case he had to do something with regard to a death penalty. If he did, he would have had to drive back to the state of Georgia in order, but these are held in Florida every year. Amelia Island one year, Destin the next. And he was prepared to hop in his car and cross over the state line in order to be able to deal with a death penalty case. If he was concerned about it, I didn't want to try and cross that line. And so that was the reason we limited it the way we did.
Any further questions for Judge Altman? Seeing none, thank you, sir.
Thank you. Appreciate it.
I see no one else signed up to speak to House Bill 146. With that, what's the pleasure of the committee? Mr. Strickland moves due pass of House Bill 146, LC 295396. Second by Mr. Atwood. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Walden.
Thank you.
Mr. Coomer. Always looking for that economic development aspect, Mr. Atwood. I don't blame you. I would too if I were you. Yeah. Mr. Lindsay. We're going to continue consideration of House Bill 141. There was good discussion on this at our last meeting. I think we arrived at the point where there was consensus on that on the point that we needed to look at perhaps tightening up some of the language, and there was also concern on the penalty provision, especially on the incarceration. The Vice Chair graciously accepted the assignment of working with the Majority Whip on coming up with some language and the substitute that you have in front of you as a result of that. I'll go ahead and recognize the Vice Chair to go ahead and speak to that if he'd like to.
I think there was a concern, thank you, Mr. Chair, first related to the way the businesses will receive notice, and you notice in lines 104 to 106, it specifies how that notice could be delivered now. It could be hand delivered by an officer looking at it, and also through mail to the address of such business establishment. I think that was one of the concerns, how they would receive notice of the violation. So that got resolved. And yeah. This actually doesn't have the language we have. The second big change was, I believe, from the original version of the bill, it's in 96.
Well, let's suspend
What's
for a
the
second.
number?
Do we not have the right substitute? Okay.
The LC that I have here is 5526S, so we have a more updated version. But we only made one additional change to it that could easily be remedied, Mr. Chairman.
It's on the penalty.
Yeah, the penalty. What I worked with the vice chairman was on line 104. There was a concern, a legitimate concern expressed by many of the committee members in terms of the imprisonment aspect, and simply just putting a period after 1,000 and cutting imprisonment for not more than 30 days or both.
All right. Let's do this. Since we don't have the substitute, Mr. Whip, would you go ahead and indulge us? We could go ahead and just push it to Monday. It'll be the first one up, just to make sure that we have the proper version in front of us.
Well, like I said,
Okay.
that was the only what I would recommend is that we work off of, if we can, go ahead and work forward today with LC 295526S.
Mm-hmm.
Okay.
Because the only additional change to that bill, to this, was that one line. Is that correct?
Well, line 96, I think we added the word owner.
And we
Did we not?
we already have that in there.
Oh.
Yeah, it's in there.
If you look at line 96,
No, I don't have the old version.
representative.
The S. The same thing.
So we already had that in there.
Okay.
In the interest of moving it along, as council's attempting to get the proper language, there really isn't that much difference between that which we've got at 5526S and the language that was prepared to be the final substitute. So let's see if technology.
There was one amendment I wanted to offer, which was to increase, while eliminating the imprisonment penalty under line 104, wanted to increase the fine, which would require that the second and subsequent conviction be a aggravated high misdemeanor and not just a regular misdemeanor.
I have no problem with that.
Okay. And the delay is actually all my fault because LC, Legislative Council, told me to pick it up, and I told Brandy and forgot to give her authority to do it.
It's all right. If that's the worst problem we've got, we're doing all right.
Trust me, that's
We're doing
way
okay.
ahead on that day. The substance, I think we all agree on.
Yeah. Let me just to make sure it's clear. I think we've got the gist of the second and subsequent that we go to. We're going to take away the incarceration, up the fine to $5,000. Let me just make doubly sure, since we're working on another version, if there's anything else in 5526S. If there's anything else that would be different, other than what we're talking about, other than what we see in 5526S.
Yeah.
Go ahead. Sure.
Yes.
For
Yeah,
what
your
line?
microphone. That's all right. Take your time.
What's that? It is my fault.
Watching the wheel.
She's walking over.
Amend by replacing lines 103 and 104 with the following. Upon a second or subsequent conviction, the owner shall be guilty of a high and aggravated misdemeanor, period. The notice required by this subsection may be hand-delivered to the... And the problem is it's not lining up because the amendment was to LC 295528S. Let me try it again. Upon a second or subsequent conviction, the owner shall be guilty of a high and aggravated misdemeanor, period, the notice. So replacing lines 103 and 104 like that.
Any questions on that language from members of the committee? That seems pretty straightforward.
Guilty of a high. Right, but that still gives you the prison.
And we don't put in the amount because we have other code sections that tell us the amount.
Okay. What about the imprisonment of the high and aggravated?
Because you don't want imprisonment.
That's right.
Right.
Okay. Give me one more second.
Sure. No rush.
Shall be punishable by a fine not to exceed 5,000.
All right. Try it one more time. Upon a second or subsequent conviction, the owner shall be guilty of a high and aggravated misdemeanor and shall be punished by a fine not to exceed $5,000, period, the notice.
Yep.
Any questions on that language from members of the committee? Seeing none, that's the only substantive change that's not reflected in 5526S, correct? Okay. Just want to make sure that's clear. Okay. Okay. I think we're in good shape. Let me ask Pamela Perkins, is it Korn or Karn? Karn, if you'd like to come forward. I see you're signed up to speak on the bill.
Yes, sir.
Please.
Thank you, Mr. Chairman. My name is Pamela Perkins Karn, and I'm the coordinator for the Interfaith Children's Movement. Thank you, Representative Lindsay, for this bill and piece of legislation, and we thank the committee for its full consideration of its passage.
Thank you. Any questions? Pardon me, seeing none. Thank you. With that, Mr. Lindsay, do you have anything else, or we just go ahead and proceed pursuant to that
No, Mr.
language.
Chairman, I appreciate once again the committee's work here. And for those of you in the crowd in particular, I think that y'all need to commend this committee. They took the first step forward in 2011 with a very tough bill dealing with human trafficking, and they made it what I thought was a pretty good bill when we came into committee, a great bill. And I appreciate the similar work this time.
Thank you. I appreciate your effort on it. It's been historical in nature. I also want to thank Ms. Travis and the Vice Chairman, Representative Pack, for their work on it, especially here today. With that, what is the pleasure of the committee? Well, do we want to go ahead and, Ms. Travis, are we looking at it perhaps as if it were a substitute? Yeah, let's go ahead and do that. Let's go. I mean, under consideration of the language that we've spoken about regarding the high and aggravated, we're going to.
So make the motion as if it's here in front of us.
If the gentleman's comfortable,
Yes, absolutely.
given the simplicity of the language.
So moved, Mr. Chairman.
Thank you. Mr. Ramsey moves do pass for LC 295528S, again, with the language as read by council just a few minutes ago on page 4, having to do with the penalty provision. Mr. Setzler, do you have a question? Go ahead, Mr. Setzler.
I'd like to thank our Majority Whip for his leadership on this issue in general as a part of a multi-year effort. I will say, just to the committee parenthetically, I do think this is one of those issues that who wants to stand up and have take any issue with the bill that deals with the subject matter. Very difficult for us to do that. I will say, as I considered my vote today in committee, I did have some questions. And it's not because I'm callous to this issue, nor am I callous to issues that I think would bring an have an effect. Action A by the legislature leads to outcome B, which is positive and meaningful and impactful. I think if we can create a cause and effect, that there's clearly a linkage between our actions and a positive outcome, I think we're well advised to do that and take not miss the opportunity to do that. I will share with the chairman. I very hesitantly, I've got some concerns. The committee hearing we had before, we talked about these in other states. We got a number of calls that have been received over the last 7 years. I don't know that we've really established a linkage between a number of calls and any specific cases that have been solved or mitigated. I think when we think about our role as a legislature in mandating that every private hotel or these kinds of locations have a sign posted in bathrooms that say, very, very clearly what the bill directs that it say. Mr. Chairman, I'm not convinced this is going to solve the problem. I think I'm induced to want to support this solely by virtue of the subject matter. I'd love to solve this. I don't want to be callous and speak against this because I'd love to be able to solve this. And I'd love for this legislature to be able to affect a positive change in this. So I've taken no actions to try to oppose this. I mean, I don't oppose Representative Lindsay. I'm not going to speak against this on the floor. I just think it needs to be said in this committee, Mr. Chairman, that we're proceeding, and I can't speak for any other members specifically, but I do know there's some hesitancy. There is a hesitancy among some members that does this very prescriptive bill, with respect to what it prescribes on private properties, does it bring about a meaningful and proportional impact to this problem? I'm not persuaded that it does. I struggle with that when I weigh that against the seriousness and our desire to affect the subject matter. I just need to say, Mr. Chairman, that this is an issue we ought to wrestle with as a legislature, but that I wanted somebody in the committee to say there is some uncertainty about the impact this will have meaningfully and how that weighs out relative to the impact and the imposition we're making on private property owners, which, if it could have a real meaningful impact, I think would be fine to do. But I'm not clear that what we're, given the significant imposition we're making, or something that's certainly measurable and we could define as being very broad in scope, I don't know that we've made the linkage between that and a real demonstrable impact on this, on what we're trying to affect. So I just want to share that for the committee, that I think I do represent some other members in our body that would share that concern.
I appreciate the gentleman's comment, and let me tell you in no uncertain terms that this does not solve this issue, and I think we go into it with our eyes wide open in understanding that it does not solve the issue. To the gentleman's point regarding, so I agree with you. To the gentleman's point about impact, I think we have to be honest with ourselves and just say, we don't know. We can't sit here and quantify exactly what the impact is going to be. I have to think intuitively that will it have a positive impact over time as you look at the increased awareness. Of course, we're sitting here thinking to ourselves, well, how many people, how many of these affected victims, and they are victims, will see one of these signs, then of those who will act upon that, maybe then, maybe a day later, maybe if it's too late. And the truth is we don't know, and it comes down to the analysis that we make every day about so much around here. What is to be lost and what is to be gained? Part of the sensitivity, the shared sensitivity that we had went to the result of that sensitivity toward what you're speaking about drove the change in the penalty provision, because we just couldn't be comfortable with a situation where you've got possible incarceration for failure to put up a sign. But there is a societal incentive, I think, in putting this up. I think generally what you'll find is that there'll be a great volunteer mentality as it relates to business owners. There will be some who won't. But I think the culture of compliance, given the subject matter we're talking about, will be actually surprisingly easy. But I do share your concern that we desperately want to quantify these things, but we can't. And so we ask, is it worth the effort? Is it worth any potential onus that goes on the private property owner, especially these individuals? Because there's a fine line between saying you must do this and all of a sudden having those requirements be so onerous that it's almost as if we're accusing them of being co-conspirators, right? But that's not what we're doing. What we're trying to do is bring that back a little bit into the realm of, look, you're not creating this issue. Help us with this issue. And I like to think that we've struck a balance on that. I will tell you without hesitation that that's arguable, and the gentleman's point is very well taken. But if we're going to err, let's err on the side of the angels. If we're going to go ahead and err at all.
If I may interject here,
Sure.
Mr. Chairman, to the legislator's point, this was an issue that was brought up in the study committee that I chaired, along with Senator Renee Utterman, and we looked at what other states were doing and what other organizations that are combating human trafficking believe is effective based on their boots on the ground, frontline experience. According to the testimony that we received in the committee, in the study committee, the folks that were on the front line trying to combat this problem did see this as a tool toward combating this issue, and something that was effective in terms of getting word out to the victims that relief is on the other end of a telephone. So to say that there's no, or to imply that there's no quantifiable evidence that this is helpful, it's good that Georgia sometimes lags a little behind, because they have seen this as being something that has been helpful in other states, according to the folks who are really out there dealing with the issue. So I do believe that it will be helpful based on the evidence that I saw in the study committee from around the country. Will it fix the problem? No. No more than HB 200 did. But HB 200 was a giant leap in the right direction. This is an additional step in the right direction, and we're going to be taking other steps dealing with this issue as well.
And I think we touched on it in the last meeting, and I don't mean to drag it out, but I do think it's an important point that Chairman Sutzler has brought up. I mean, have we seen, you looked at the data in other states. Yeah. Have we heard anything either quantified in data or even anecdotally about some sort of compliance nightmare occurring in other jurisdictions?
As a matter of fact, we have not seen any evidence of a compliance nightmare based on what's taking place in other states. And this is generally, folks sometimes ask, well, how do you enforce it? A lot of times you enforce it by private citizens organizations such as some of the ones that testified earlier who go into these establishments and say, hey, you're now, who've been trying to get this sign posted in these establishments already, say, hey, you are in fact required to do so. Those are the best ways to enforce this legislation, is it provides those folks who have been trying to get the word out to the victims through these various establishments, that it gives these folks an additional stick, for the want of a better term, toward getting these notices posted. And it has proven to be something effective in those other states.
Mr. Chairman?
Yes, sir.
If I could, and if I had confidence I could so much as get a second on the motion, I might offer an amendment. I think what I would perhaps offer is that this in essence is a program. I don't think it's going to be onerous on a hotel to buy a plastic placard and have it in their. I mean, I'm not making the case that it's onerous, other than it becomes a sort of a governmental command on private property to do this and to do that. And we want to be sensitive to that. In as much as this is a program, really, and based on the subject matter, I don't know that 50, 60, 70 years from now that folks will ever know why we did this. I mean, it's going to kind of, I don't have any sense this will ever be repealed from the books. This will just, because of the nature of it, who's going to want to offer the bill to repeal this if we find that this isn't meaningful? To me, this is the kind of thing, much like some of our tax credits, that maybe you do for a 10-year period and sunset it in 2023, so that we have 10 years to evaluate it. No one has to take any action to get it off the books. But if we find in the 2022 session that it's sunsetting, maybe we say, listen, we're going to do this again indefinitely. We get, and maybe then we make it permanent. We've got a basis in Georgia, 10 years of real empirical data and experience on how to do that. I would be inclined to offer that as an amendment, to say this is going to be a 10-year program that we can revisit in 8 or 9 years and see if it works. I don't know that I would get a second for that motion, but to me, this seems like the kind of thing that we'd be well advised to consider in that kind of arrangement.
Let me just say, I mean, without persuading or dissuading, and be very clear about that. I mean, just to the gentleman, the chairman, is that when I say, are there any amendments, I'm not just saying that. I actually am asking, are there any amendments? So I would just offer that by way of information to any member.
And let me also add that this is the type of bill that I do think would probably be helpful to have go to the floor with modified open. If that's something that you feel very strongly about on the floor of the House, I wouldn't have any problem with letting the will of the whole House decide whether or not this is something that should have a sunset in 10 years. And I would rather see that than have the bill further delayed today.
Oh, the bill's not going to be delayed today.
In case you're looking for additional language or think this is his last chance, that's what I'm trying to say to the representative. I'm a great believer in those bills that we can bring to the floor modified open, which is to allow amendments on the floor that we ought to do so. And this would be the type of bill that I would suggest to go to the floor modified open.
That's food for thought, for sure.
Could I ask council to consider, should I make that motion in the next 90 seconds, what the language might sound like? January 1st, 2024, 23. Okay.
The posture that we're in is that I asked for a motion. I believe I got it, if I can recall, from Mr. Ramsey. I don't recall. I'm sure there was a second. I don't recall who said it, but I think at that point I saw Chairman Setzler's light. So let me go ahead and ask, is there a second? Second by the Vice Chair. Are there any amendments? Mr. Setzler.
Mr. Chairman, with great respect to my friend our minority whip and majority whip, thank you. I'd like to offer an amendment that this code section should stand repealed effective January 1st, 2024. Assuming it enjoys passage this year, it would go into effect either upon the governor's signature. Sometime this year there would be sort of a warm-up period to get started, and then 10 years of implementation, in which case we could evaluate it. If it was not required beyond that point, and these signs have been deployed all around the state in hotels and similar kind of facilities, it certainly could become a culture of compliance where individuals could choose to put these signs, and even if it weren't required by law. If we have this in place for 10 years, I would expect many folks would choose to continue to do it. But I think as a mandate, it might be better advised to try this 10 years for a first round.
On the gentleman's amendment, let me ask council to just specify what line that would be in the revised sub.
Between lines 106 and 107, and I'm trying to be sure that I'm saying the right. I'm not sure if it's standard field or salvage field. You give me license on that, otherwise
We'll give you license on that. All in favor of the gentleman's motion, gentleman's amendment, signify by saying aye.
Aye.
Opposed? The ayes have it. One opposed, and the amendment is adopted. Any, Mr. Ramsey? No. Okay. Are there any further amendments? Seeing none, we have a motion and a second of due pass of House Bill 141 by substitute. Council, will you just call out the LC that you have, just for the record? And then that's the new version that's the version we're talking about? I got you. Okay. By substitute, all in favor say aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Whip.
Let me also add, I agree with Jim said. I think it would be a good, effective program, but I think in 10 years we don't know if everything's going to be digital up on the wall or not. We're not even have paper placards anymore.
That's a good point. All right, there being no further business before the committee, we are adjourned, and we will be meeting Monday afternoon pursuant to our regularly scheduled time. Thank you, members.